I wish to welcome you, and in the course of the next 1 hour, we will be discussing questions of the Commission. Now, when you look at our mandate, the mandate of protection and promotion of human rights in Africa, that mandate is realized through a whole lot of strategies, through decisions, through recommendations which we make as a commission to states. And those decisions, those recommendations are packaged in periodic reports in terms of Article 62 of the Charter. They are also packaged as our communications procedure, and also clearly through other innovations, other tools. Now, over time, I think you might say that the Commission has made invaluable determinations, but there also has been a clear implementation gap where states fail or part fail to implement decisions which have been made by the Commission. Now, we do have responsibilities to facilitate implementation of these decisions and recommendations. But clearly, we need to keep in mind that actually states are the primary duty bearers in the implementation discourse. And of course, at the level of states, not only do you have governments themselves, you also have other actors. You have national human rights institutions, you have non-governmental organizations who also play roles at the domestic level to ensure implementation of the decisions which we make. So this really is a context within which we are having this discussion today. So this panel draws from 3 strands of work. The Commission itself has been undertaking a series of events which have focused on implementation of its decisions. So this began last year in Dakar with the regional seminar on implementation of decisions of the Commission. So that was in August in Dakar last year. But also in Zanzibar, again I believe in August of this year, we also held a further implementation sub-regional workshop. At the same time, the Network of African National Human Rights Institutions has also been doing some work with its members around how to ensure effective, NHRIs play effective roles in this regard. And finally, we've had a collaboration between the Human Rights Implementation Center of Bristol University and the Center for Human Rights of the University of Pretoria, again, which has been doing some important research work in this area. So then this is a context within which we have this panel, which will help us to take stock on how key players may strengthen implementation of the Commission's decisions. And so then, at this point, I wish to welcome speakers who will be making statements. Please, for each of you, your statement can last for only 5 minutes, so that then we'll also be able to have engagements at the end. The representative of a state, and I believe he is, I hope he's here, Pacharo Kaira, from the Malawi, from Malawi. So you're welcome, sir.
Thank you.
5 minutes.
Thank you. Thank you very much, Commissioner Mute. Again, we are honored to be able to share our experiences as Malawi in terms of the implementation of decisions of the African Commission. Malawi's relationship with the African Commission can be divided into 3 parts. From 1989 to about 1994, we ratified the Charter in 1989. So the first part of our relationship with the Commission, 1989 to 1994, was of indifference, where we practically did not have any relationship whatsoever with the Commission. in terms of submission of state party reports, in terms of honoring what the Commission required of us. The second part would be from 1994 to 2013, where our interaction with the Commission improved in the sense that, firstly, we contributed a commissioner to the Commission, that is Commissioner Vera Chirwa, who was also a special rapporteur on prison conditions. During that period, I think the visibility of the Commission in Malawi greatly improved, but however, it was still not very satisfactory. The third part would be 2013 to present, where I can say that the engagement of Malawi and the Commission has significantly improved. And during that period, we have witnessed several things. Number one, Malawi has been able to submit its initial state party report. Number two, we have consistently attended the sessions of the African Commission, and we have also successfully implemented the concluding observations, guidelines, resolutions, model laws of the Commission. So the question would be, what changed between 2013 and to the present, and what have we learned, or what led to that change, which we can share in terms of how we have successfully implemented the decision of the Commission. The first lesson we have learned is that there is need to have a national focal point as far as issues from the Commission are concerned. So in 2013, the government of Malawi decided that the Minister of Justice, the Human Rights section in the Ministry of Justice, would be the national focal point in terms of the African Commission, meaning that any communication from the Commission, decisions of the Commission, would be channeled through the Ministry of Justice. So all key stakeholders in Malawi know that African Commission issues go through the Ministry of Justice. The Commission on this end also knows that if they want to communicate to Malawi, they go through the Ministry of Justice. So the first point that helped us in terms of implementation of decisions, concluding observations, is that we have a national focal point. Secondly, the need to have a national forum on issues coming from the African Commission. So what we did in 2013 was to establish a national task force on the African Charter. And this national task force has several responsibilities. The first one is that the task force is responsible for the preparation of our reports. So our reports to the Commission are done through this national task force, which is chaired by the Minister of Justice. Secondly, the task force acts as a national forum for the dissemination of concluding observations, resolutions, guidelines, principles, etc. of the Commission. So each time the Commission comes up with concluding observations on Malawi, it comes up with guidelines, principles, resolutions which need to be implemented by Malawi. Those guidelines and those documents are referred to stakeholders through the national task force. And then thirdly, the task force acts as a national forum for consensus building on human rights issues, as it is also an interface forum between government and civil society. So the national task force is structured in such a way that it has membership from government ministries, government institutions, but it also has membership from civil society organizations. So it acts as an interface forum where the government and civil society discuss issues related to human rights, especially issues coming from the African Commission. So it is used as a consensus building forum. Number three, it is also used as a platform that acts as an early warning system on human rights issues. So various human rights issues that come from the Commission are normally flagged at this national task force, such that when the Malawi delegation comes to the Gambia for a session, even issues which are raised by the Malawi Human Rights Commission or raised by civil society are not new to the Malawi delegation, because they would have most likely have been raised already domestically during the meetings of the national task force. Number five, the task force also acts as an advocating forum. So civil society organizations will come to the government to say, we want to advocate for this, what is your view? The government, on the other hand, also uses the same task force to advocate for issues which it wants to advocate. The number 3, we have also witnessed an increased awareness of the African Commission domestically. And
The
I
time
think,
is up, sir.
and, oops. Okay, I had 1 or 2. Can you give me a minute? Just a minute?
Quickly.
Okay. All right, I had a few lessons or recommendations going forward. Number 1, the need for African states to share best practices. I think African states have various models which are working domestically, and it is important for us to be sharing those so that we learn from each other. Number 2, using non-contentious issues to build consensus, and I've given an example here on the age of the child when Malawi reduced the age of the, raised the age of the child from 16 to 18. And then lastly, I'm saying that the Commission should, despite resource constraints, increase its visibility and interaction with state parties, either through embassies or events, as well as visits to various state parties. Thank you.
Thank you very much. Thank you very much. So then, obviously, one critical actor in the whole process of implementation is a complainant. And so I want to invite Christophe Bado from Movement Burkinabe.
Merci. Merci Madame la Présidente, merci Monsieur le Modérateur. Donc, je représente le mouvement burkinabé des droits de l'homme et des peuples, qui est un mouvement qui a été créé le 19 février 1989. Donc, nous allons bientôt fêter nos 30 ans. Et nous avons donc été associés donc, à ces panels pour donner notre expérience en matière de mise en œuvre donc, des recommandations donc, de la Commission en tant que représentant donc, des plaignants de notre pays. Et j'aimerais ici donner 4 points en ce qui concerne donc, notre expérience. C'est qu'une fois que la Commission donc, africaine adresse des recommandations donc, à notre pays, de retour donc, au pays, au niveau donc, du mouvement, nous donnons les moyens d'organiser donc, des séances d'information sur les recommandations. L'objectif effectivement donc, de ces séances d'information, c'est d'informer l'opinion publique nationale de ce que effectivement donc, des recommandations soient adressées donc, à notre pays et qu'il faut qu'ensemble effectivement donc, nous travaillons à avoir un regard donc, là-dessus pour que ces recommandations puissent être mises en œuvre. Et vous savez, un mouvement comme le Burkina Faso, le MBHP, nous avons 45 sections dans les 45 provinces du pays. Nous avons une section en Côte d'Ivoire, une section en France et une section au Sénégal. Nous travaillons également donc à ce que toutes ces sections-là puissent avoir les recommandations et que chacune à son niveau puisse se battre autour de ces recommandations-là pour leur mise en œuvre. Le deuxième point, c'est la participation à des cadres de réflexion sur la mise en œuvre des recommandations. Ces cadres de réflexion sont souvent donc, organisés donc, par le ministère en charge des droits humains qui nous y invite. Et souvent, ces cadres de réflexion également sont le fait d'une coalition d'organisations de la société civile où nous discutons ensemble effectivement donc, des stratégies à mettre en œuvre pour une meilleure mise en œuvre effectivement donc, de ces recommandations-là. Donc c'est également important. Rien que la semaine dernière, nous étions avec le ministère pour discuter sur la mise en œuvre des recommandations de l'EPI, par exemple. Le troisième point, c'est les mobilisations citoyennes. Pour ceux qui connaissent le Burkina Faso, vous savez que nous avons une société civile assez active. Donc il nous arrive effectivement donc, d'organiser donc, des mouvements, des marches, des sittings, des meetings. Et au cours de ces mobilisations citoyennes-là, il y a certaines recommandations de la Commission que nous traduisons donc en points de revendication dans nos plateformes revendicatives. Vous voyez normalement les points tels que les questions liées à la vie chère, les questions liées à l'impunité des crimes économiques et de sang sont par exemple à la corruption, sont prises en compte dans nos plateformes revendicatives et nous nous battons autour pour qu'effectivement l'État puisse mettre en œuvre effectivement donc ces recommandations-là. Et le quatrième point que je souligne ici, c'est la participation aux instances africaines et internationales de promotion des droits humains. Et nous avons ce matin, par exemple, livré notre déclaration sur les droits humains au Burkina Faso. Nous participons à d'autres cas tels que le Comité des droits de l'homme, l'EPU, l'examen périodique universel, où nous interpellons encore donc, de vive voix l'État sur la situation des droits humains et sur la nécessité donc, de mettre en œuvre les recommandations qui sont adressées au pays. Donc, en ce qui concerne donc, les obstacles qu'on peut souligner dans la mise en œuvre, ces obstacles-là, c'est notamment le manque de volonté politique souvent qui fait que les recommandations ne sont pas mises en œuvre. Parce que souvent, il y a beaucoup de promesses, mais dans la réalité, il n'y a pas véritablement de mesures concrètes pour la mise en œuvre en réalité de ces recommandations-là. Nous avons par exemple en 2014 fait une campagne pour les conditions de détention. Nous n'avons pas été écoutés donc, par le gouvernement. Et en 2014, il y a eu l'insurrection populaire. Il y a eu des ministres qui se sont retrouvés donc, en prison. Nous les avons rendu visite et ils déploraient effectivement donc, les conditions de détention. Donc on leur dit, bon, c'est une situation qu'on pouvait éviter si effectivement on avait mis en œuvre les recommandations donc, de la commission. Il y a aussi la méconnaissance donc, de la KDHP et des mécanismes qu'elle offre par certains praticiens du droit. Parce que quand vous prenez donc, la justice, on évoque rarement donc, les mécanismes africains de droits de l'homme. Je pense que c'est à travers donc, ces sanctions-là qu'on pourrait donc, pousser les États à véritablement donc, prendre en compte les recommandations pour éviter d'être... voilà. Et le dernier point que j'aimerais aborder, c'est la faible implication des populations. Il faut travailler effectivement donc, à ce que les populations elles-mêmes s'impliquent dans le processus effectivement, donc, de mise en œuvre donc, des recommandations. Et je pense que ça s'adresse à nous, les ONG, c'est de travailler effectivement donc, à dire aux populations que les droits de l'homme sont une quête permanente, que les droits de l'homme s'arrachent, les droits de l'homme ne se donnent pas. Et sur ce point, effectivement, donc, j'aimerais terminer en citant Norbert Zongo, qui est ce célèbre journaliste burkinabé assassiné donc, en 1998, qui disait ceci: quand le peuple dort, le gouvernement aussi dort, et lorsque le gouvernement se réveille, c'est pour constater que quelqu'un est mort et il replonge dans son sommeil. Donc, la lutte continue. Merci.
Thank you so much, sir. And actually for exactly being on time. Thank you so much. As I said earlier, the Network of African National Human Rights Institutions has always having a specific program on the question of implementation of decisions of the Commission. And so the next statement then will be from the Network of African National Human Rights Institutions, Nhgri, and Maureen Puisa.
Thank you, Honorable Commissioner Mute, for according me this opportunity to speak during this panel session. The Network of African National Human Rights Institutions draws its membership from 44 African national human rights institutions, and we do have, or rather NHRIs are independent state bodies established under internationally agreed United Nations Paris principles. Further, under the African Charter on Human and People's Rights, NHRIs are recognized under Article 26 and 45(1)(c) of the African Charter. And under this charter, or rather under the rules of procedure of the Commission, Rule 67 accords NHRIs the affiliate status to engage with the African Commission during various sessions. Therefore, what is the role of NHRIs in the implementation of decisions of the African Court? This role is twofold, pegged at the national level and the regional level. At the national level, NHRI's roles involves engagement with government through the advisory role, and this is through convening or engaging relevant specific departments responsible for specific findings and implementations of findings from the African Court. NHRIs also provide expert advice to the state on the practical measures required for the implementation of decisions from the regional level. Furthermore, NHRIs convene or facilitate consultations between various national stakeholders to enhance coordination, and this is done through consultative meetings or workshops, and therefore it encourages the government to adopt action plans for the implementation of decisions that come from the African Court. Also, NHRIs engage with the judiciary and the legal fraternity through the Office of the Attorney General to just sensitize them on the decisions that are emanating from the regional level and the applicability at the national level. NHRIs also engage with Parliament, where we have human rights parliamentary committees, and they alert them on the decisions that come from the regional level and what are the remedial measures that need to be taken to implement these decisions. Further, NHRI promotes collaboration with civil society, as has been mentioned by my fellow panelists from Burkina Faso. It also creates awareness of the decisions that come from the African Commission through use of media, through publishing the findings of the decisions that come from the regional level in relevant local languages, and also reporting on the status of implementation of these decisions using various mechanisms such as the Universal Periodic Review Mechanism and the African Peer Review Mechanisms. It also integrates the decisions into the work of the NHRIs, and this is done through ensuring that the extent of the implementation of this decision is reflected in NHRI's annual reports. And also it establishes focal points to follow up on the decisions that come from the African Commission. NHRIs also promote stakeholder participation in the drafting of state reports to the African Commission, and it highlights the instances of the failure of the states to implement these decisions. At the regional level, NHRIs that have been accorded affiliate status are able to attend the sessions of the African Commission, and further, they're able to give a statement on the extent that state has implemented the decisions from the African Court. NHRI is also involved in the drafting of the state reports, and further, they're able to submit alternative reports to the African Commission in advance of the examination of the state report. They're also able to submit questions to commissioners in advance so that they're able to use these questions during oral examination of state reports. NHRIs are also able to follow up on concluding observations or request that information be put in concluding observations for follow-up by states. What are the challenges that NHRIs face in terms of implementation of decisions? The first is the lack of political will from the government to implement these decisions. We also have the issue of lack of knowledge by NHRIs on the procedures and operations of regional human rights mechanisms, lack of information sharing between NHRIs and regional human rights mechanisms. There's also in some NHRIs the absence of a focal point to undertake this work of implementation of decisions. There is also in some NHRIs weak technical capacity to effectively engage with the regional human rights mechanisms. And lastly, inadequate coordination among regional human rights bodies, which makes it difficult for NHRIs to engage with these bodies. So as has been mentioned by Commissioner Mute, Nhgri has in the past engaged with NHRIs to just understand what challenges NHRIs face in the implementation of decisions that emanate from the African Court. And through this, we have been able to develop guidelines for NHRIs to use in the monitoring and implementation of decisions that emanate from the regional level. And further, Nhgri has been able to support two NHRIs, namely Kenya and Cote d'Ivoire, in convening national stakeholders meetings and to develop action plans for the implementation of decisions that have emanated from the African Court. In conclusion, what are the strategies that should be adopted by NHRIs, the African Commission and regional human rights bodies, and the AU member states in terms of moving forward in implementation of decisions? For NHRIs, we strongly advise that we establish focal points and committees that will be dealing specifically on the issue of implementation of decisions. Then also NHRIs should adopt a collaborative approach between civil society to leverage on the existing capacity of other actors in the regional mechanisms. NHRIs should also include information and implementation of decisions in the alternative reports to the African Commission, and they should continuously use the advisory role to advise the state to monitor and promote implementation of these decisions. To the African Commission, sorry, Commissioner, can you allow me 1 minute to wrap up? So to the African Commission, we strongly suggest that African Commission should participate in the efforts to establish strong NHRIs. African Commission should establish strategic avenues for information sharing between NHRIs. African Commission should also ensure regular reporting on the human rights and humanitarian situation in the region to the AU Peace and Security Council. And to the AU member states, we recommend that the states should improve the reception of regional judgments and the broader application of international law in their legal systems, and lastly, to establish and support NHRIs with strong legal frameworks in accordance with the Paris Principles, guaranteeing them independence and adequate resources with the capacity to effectively exercise their broad mandate. Thank you, Commissioner.
Thank you, Honourable Commissioner, and thank you to the African Commission for the opportunity to hold this panel and present some of the findings from the project that we've had for the past 3 years in collaboration with Franz Velian at the Centre for Human Rights at the University of Pretoria and the Open Society Justice Initiative, amongst others. We have been trying to track the extent to which recommendations made by the African Commission and the African Court and UN treaty bodies in a number of African countries have actually been implemented. So we've looked at a number of cases and we've looked at the specific recommendations, and we have spoken to a range of individuals, government representatives, victims and others to see whether they've actually been complied with. Overall, I would say there is a lack of visibility on what action has been taken by states to implement decisions. And we found in general that there is more implementation than at first appears to be the case. That's not necessarily full implementation, but the picture is maybe more promising than one might think. A few key points I want to raise. It doesn't appear to be so relevant whether the decision is an African Commission decision or an African Court decision. What is more relevant is that these decisions and judgments do not necessarily trigger a domestic process or domestic mechanisms in the same way that a domestic court judgment would. And so that has a number of consequences. So often there is a lack of understanding about what precisely should happen at the national level once the African Commission has adopted its decisions. In some countries, and we heard the good example from Malawi, from the delegate from Malawi, there are mechanisms, there's a national committee in place, but in any other countries that is not the case. And so it's not often clear whose responsibility it is to start the process of implementation. And as a result, it's often left to the complainant or the victims to initiate that. The more complex the recommendations, the more time this will take to pull together relevant government departments, and more difficult that will be for the complainant and victim. So, for example, obtaining compensation may appear to be a relatively straightforward recommendation, but actually the process that the victim will need to go through at the national level will require them, we found in the cases we looked at, to engage with the Ministry of Finance. They will need local lawyers. They may not even be able to have the money paid into their own bank account. So there are a number of challenges. And I think further support needs to be given to states to assist them in developing these technical administrative procedures so that these cases can be implemented. In terms of what the African Commission can do, we heard from all stakeholders that there is a role for the Commission in monitoring its own decisions and a desire from the parties, governments and complainants, for the Commission to have an ongoing dialogue and discussion with them post-decision on what measures the state has taken to implement. We would recommend that there is more clarity and specificity in the recommendations, and that the Commission makes it clearer how it came to some of the decisions it did. For example, if it's going to recommend certain actions are taken by the state for its credibility and to ensure its independence. So finally, I think the Commission, we would recommend, should use the momentum that it has gathered from focusing on this issue in Dakar and in Zanzibar and other panels and here today, and carry through some of the very important recommendations that have come out of those and the commitments it's already made. It does need to be reiterated, and it's already been stated here, that it is the responsibility of the state to implement, and should therefore also be the responsibility of state actors to initiate that implementation. But that there could be some guidance produced by the Commission in collaboration with states on the step-by-step process of how they may go about doing that, and maybe considering model legislation for states to be able them to trigger these domestic processes once the decision of the Commission has been reached. We would also recommend the African Commission operationalize the proposed unit for implementation and increase visibility on its website on measures that states have taken to implement these decisions. Finally, we would recommend a number of things that the Commission can do to enhance the likelihood of implementation. For example, by inserting in each of its decisions where it finds violations, a recommendation that the state not only publish the decision in line with some of the ways in which the African Court has done so, but also that the state publish the measures it has taken to implement that decision. We stand available to assist the Commission, states, parties, complainants, and other stakeholders in furthering the effectiveness of the implementation of African Commission decisions. Thank you.
Okay, thank you so much. So before I open the floor, perhaps I should also finish the point which I made at the beginning, which is that apart from the work Nhgri and the center, or the two centers, have been doing, obviously the Commission has also been quite concerned about implementation of its decisions. And in the last 2 or so years, it has taken certain actions. And it is also proceeding, it will continue to take certain further actions to ensure implementation of its decisions. So, yes, indeed, we held 2 regional meetings over at least 3 days. And for both regional meetings, we invited representations from all states, and so these would be governments, but also national institutions and civil society organizations. And arising from the discussions which took place in those regional workshops, the Commission is taking a number of actions. Obviously, we need to disseminate the results, the discussions and the results of those 2 meetings. And so the Dakar proceedings should already be online. We intend that the Zanzibar proceedings will also be online, so that at least that record is there. But then, over and above the record, there will be a plan of action which will take account of what various responsible actors should do in order to ensure effective implementation of decisions of the Commission. Now, some of the arising issues, and which, in fact, in some instances have begun to be undertaken, would be in respect of national human rights institutions that actually they do play critical roles at the national level. And so what you might have noticed, some of you who look at our jurisprudence, is that in some of our latest decisions, our latest communications, we actually have assigned specific responsibilities to NHRIs or an NHRI which we have named actually as part of the decision to do or to facilitate or to support the state in implementation of the decision. So we have language, and we have actually specifically, I know in at least one instance made a decision in a communication which has included that specific direction to an NHRI. And so because we believe that NHRIs indeed can support implementation of our decisions. Clearly, the other thing which we need to do is we have to have an implementation monitoring framework on compliance with the decisions. And here we're thinking about an approach which is intra-institutional. So that we're speaking about the African Commission, but also possibly the African Court, also the Committee on the Rights and Welfare of the Child, because there may be leverage, there may be ways of gaining an advantage from that. Also, we are engaging the policy organs so that, because we recognize in the end, the responsibility really is on states to implement. So the discussion has been that there should be an executive committee, our committee of the executive council, which is formed to actually oversee implementation, particularly where states are recalcitrant to actually undertake implementation. And then, as Professor Mari has mentioned, the whole idea of establishing a dedicated unit for implementation of decisions of the Commission that obviously subject to resources, technical expertise, and all that, that is something also moving forwards we need to be doing. Final two issues, the question of developing a comprehensive online communications handling system. That's something which we have to keep in mind. Also, presently we're in the process of revising our rules of procedure. So again, some of the underlying issues, some of the suggestions are arising, will then also be taken account of as we finalize a revision of our rules. So I think on that basis, we can open it up. We have some time where perhaps some of you, distinguished delegates from states, also distinguished delegates from other institutions, may have participated in our regional meetings, either in Zanzibar or in Dakar, or perhaps even if you did not participate, you got reports from your colleagues, or you may have issues with which you'd wish to engage this panel. If we can have then indications on who wishes to take the floor, so that we can listen to you and get responses from the panel.
Thank you, Mr. Chairman. And thank you for this very constructive, I think, presentations from the panelists. Mr. Chairman, I think it is worrying if the implementation of your decisions or recommendations becomes a problem. Because as member states, we are committing to these continental instruments, and therefore the expectation is to ensure that all that we have committed to is fully implemented. Now, I have a suggestion in view of some of the models that are already existing. Obviously, the African Union Commission was created, and under which we have the regional economic communities or regional mechanisms that are bringing member states closer to the African Union Commission. And in the regional economic communities, we have some structures which address a number of issues which are complementary to the African Union agenda. Now, if this is the case, the recommendation would be to use the regional economic communities or regional economic mechanisms at least to start trying to bring member states to their commitments to understand that there is a need for us to implement this. For instance, what the African Union does with the Peace and Security Commission, Peace and Security Council, was to create liaison offices in the regional economic communities. And the same regional economic communities have established the liaison offices at the African Union Commission. So if we find it a little bit expensive to do so, why don't we beef up the liaison office or offices both at the regional economic communities and at the African Union Commission to address these issues, so that at least you create a mechanism whereby there is a monitoring and evaluation of the implementation of your decisions. This is already existing as a structure, and I think if we look into that, it will be much better. And of course, member states find themselves closer to the regional economic communities or mechanisms probably than at the African Union Commission. We saw it happening, it is happening up to now, and I think we can draw the lessons learned from that and ensure that the implementation of our recommendations or decisions here is taking place. I want to submit, Mr. Chairman. Thank you.
Mr. Chair and Madam Chair, for first of all providing this opportunity during this session for the discussion and shedding light on this important issue. I think it's very important to deal with the problem of the visibility of the outcomes of the Commission in cases that is brought to its attention, and that should be done in various ways, as has been discussed and highlighted by some of the speakers, through NHRIs, through different methods in reaching out to the governments responsible. I think one of the starting issues to deal with this important matter is to maybe resolve the situation whether whatever comes out from the Commission is a recommendation or a decision. It's understandable, of course, that a decision by the Commission, deals with its own work, internal work. It can decide on its own, of course. But then when it comes to cases involving member states, whether these are recommendations or decisions, this has to be resolved based on the charter, of course, that is establishing the Commission. And from that, we can go further to see the level of commitment to the implementation of these outcomes. So I think this is the starting point, really, that needs to be addressed. The other thing is also related to that is, in most cases, in other treaty bodies throughout the world, whatever they come out with are recommendations, in fact. So this is the normative trend internationally. So to consider that the international norm is that whatever comes out of treaty bodies are only recommendations, and it's up to the member states to accept them or not. And the level of acceptance, of course, is decided by the member states. But then to say that this is the thing on the international level, but then it's different when it comes to the ACHPR, I think there's also, this is a point that needs to be addressed. Another thing is the relationship with NHRIs. NHRIs, to our own understanding, in Egypt at least, is that they are independent bodies, independent from government, even though they might be decided or established by a decision by the executive power in some cases. It's not the case in Egypt. It's by the legislative body in Egypt that is NHRIs are established. But anyway, in other cases, they might be established, and they were in the past in my own country, established by a decision by the executive body. However, they remain independent in the way they act. So when the Commission comes out with outcomes that gives directives to NHRIs, that is in fact an infringement on the independence of these NHRIs. As member states, as Egypt, we do not accept, anybody from our executive bodies to give directives to our own NHRI because we respect their own independence. But in the same manner, we reject that they receive directives from any other body, be it national or international or regional. So again, I think this is something that needs to be borne in mind when dealing with NHRIs, how to preserve their independence, because this is actually a major element in the preservation of the effective role of NHRIs. When it comes to the visibility, my third point, when it comes to the visibility of the decisions and outcomes of the Commission, there is a vast list of alternatives that need to be considered in reaching out to the member states. But the most important thing, I believe, is, and that is the starting point, is to convince the concerned member state that the Commission has reached its own outcome through a transparent process, one that is credible, that would make the member state concerned able to be convinced by the outcome, and then would cooperate in its implementation. Only through that process, a transparent process, restoring the credibility of this Commission, that member states would be more than willing to cooperate and actually implement the recommendations or outcomes or decisions, whatever you name them, by this Commission. Thank you very much.
Thank you very much.
Just to respond to some of those comments, the Honourable Delegate from Lesotho mentions the use of existing structures, and I think certainly what we've seen is that there isn't sufficient use made of mechanisms that are already there, and they don't often talk to each other. So there's a lot of untapped potential, and it's not just at the regional or sub-regional level, but it's also at the national level. So the Honourable Delegate from Malawi mentioned his example of how that committee works in the country. What we've seen in other countries is that whilst you may have a well-functioning mechanism, for example, to respond to UPR recommendations or state reporting and so on, you don't necessarily have something similar to respond to African Commission or African Court decisions or judgments. And given that these decisions and judgments are relatively few in number, it sometimes makes sense to include them in those existing mechanisms. On the points raised by the Honourable Delegate from Egypt, the issue about the Commission's decisions being recommendations or decisions and how that distinction is resolved. We have seen, certainly in the interviews and workshops that we've had with governments, and we've been speaking to them, and this is governments in Africa as well as in Europe and the Americas. We've been speaking to them about decisions of the commissions, the regional commissions where they exist, and UN treaty bodies. And we haven't heard from the states that we spoke to, who are quite candid with us, that the binding or otherwise nature of these decisions was the reason for failing to implement. There were other factors, but it was not used as a reason for not taking measures to comply with the decision. The issue about visibility, I think, as I said in the presentation, clarity from the Commission, well-reasoned decisions certainly does appear to have some influence on the responses states take, and providing good sort of jurisprudence and rationale for how the Commission reaches certainly the recommendations it makes can be very powerful. And I think complainants and victims have a useful role to play in proposing very specific recommendations and reparations to the Commission during the drafting of the submissions. Thank you.
Thank you, Honorable Representative from Lesotho and Egypt, for your insights and questions. I will speak to the question on the role of NHRIs with the African Commission. And my view would be that NHRIs, as you rightfully put it, are independent state bodies, and their broad mandate is the promotion and protection of human rights. On the issue of receiving directives from the African Commission, my response would be, given the affiliate status that NHRIs have and their working relationship with the African Commission, they do have a role in terms of monitoring compliance of states in terms of international and regional human rights framework, and further, the extent to which states actually implement decisions that emanate from the regional level. Yes, so that would be my response.
Donc, j'avoue vraiment que je n'ai plus grand-chose à ajouter après tout ce qui a été dit. Juste vraiment interpeller l'ensemble des acteurs, les États en premier, à travailler véritablement donc à mettre en œuvre les recommandations donc de la Commission. Cela y va effectivement donc de la crédibilité de cette Commission. Et cela va permettre effectivement donc, aux victimes en tout cas d'avoir une meilleure protection en tout cas de leurs droits humains. Merci.
Kaira.
Just to highlight what I said, that I think African states should exchange a bit more of best practices from their countries. I think in our respective countries there's something which is working, so we need to talk to each other and share those best practices. Thank you.
Thank you, Chair, for giving me the floor. I'm going to address two issues. The issue of the nature of the decisions of the African Commission, and to make another proposal. Regarding the issue of the nature of our decisions, which have been qualified as recommendations, as has been rightly pointed out by Professor Nhgri, this basically has not been the reason for non-implementation. Because when you look at the fact that the African Court on Human and People's Rights, whose decisions are qualified as binding in the protocol, still has this problem of implementation, then the conclusion is that the reason should be elsewhere. And I believe that in 1981, when the charter was drafted, the nomenclature at the time was recommendation, and we had evolved to binding decisions recently when the protocol on the court came out, but it has not made any change because the same cry which is taking place, lamentation here over non-implementation, is the same lamentation which is taking place at the level of the African court. And I believe that based on the principles of Pacta Sunt Servanda, I mean, the conventions are meant to be implemented on the basis of good faith. Otherwise, the whole notion of international law shouldn't even be here, because there are no basic sanctions that you can impose on any party, whether they are said to be binding or recommendations. So I think what we require of the state will be a little bit more of a political will for the implementation. Many reasons have been advanced. Some are financial reasons, some are the timelines given by our recommendations, and so forth. But I think today, the debate on the nature of our decisions, it shouldn't even arise again, because I believe that it's a question of nomenclature. Then there is an evolution in the supplementary treaty, protocol to the treaty of establishing the ECOWAS court. In its Article 24, the decisions have been said to be binding to the extent that they can be implemented in the national jurisdictions by obtaining a writ of execution directly, so much that you don't have to go through any other process of focal points and all these recommendations we are making now. So if the protocol one day can be amended to integrate a provision of that nature, so that once you obtain any litigant who obtains a decision from the African Commission or from the African Court can obtain a writ of the execution directly at the national level to be able to implement, because I believe that it's very important. The finality of every process, legal process, is that the litigant should be able to benefit from the fruit of a decision. But if we have to go through so much hurdles to arrive there, then I think it becomes somehow regrettable. So if that provision can be adopted one day, then it will be to the advantage of the victims of human rights violations. Thank you.
I think just to say that obviously the decisions which we arrive at, and I take the point about ensuring that there is a process, a credible process which we use to arrive at decisions. And indeed, we do have, in respect of each communication, a clear procedure for hearing all the parties. But having said that, I want to thank the panel, excellent panel, for helping us to engage on these issues. And thank you so much that that which we deferred in Nouakchott, we have been able to do this afternoon and quite well. I appreciate all of you panel, and let's appreciate the panel. Thank you so much. Thank you, Chair.